Yep. All right.
Good morning, everyone. This is Jim Szymanski. I'm Director of Public Affairs for the Washington Retail Association. We're located in Olympia, Washington. In case you're coming in from outside the state capital, you can find out more about us, by the way, on our website, retailassociation.org. I want to thank all of you for taking some time out of your schedules today to be here. We think we have some important ground to cover with you on a new body of law, really, in Seattle that came into being to some degree without much fanfare, but it's important for anybody who hires in Seattle or works in Seattle to know about. Our assumption is safe that everybody who should know about this does not, and so we're grateful that you're here today, and we're pretty confident that you'll come away having learned some things you didn't know about those laws and how they affect the workplace in Seattle. I do want to call your attention to a couple of things before we get started and turn this over to Scott Hilderbrand, our presenter today. You'll hear about Seattle's minimum wage law today. You'll hear about wage theft and an ordinance that's put into place to deal with that. You'll hear about Seattle's new sick and safe protection laws, safe harbor protection laws, and also about new protections in place for applicants for jobs that may have criminal records. There are some protections you'll learn about that are controversial but important to know about. I do want you to know that if you've come to this late or you come up with a question or a curiosity a couple of days after this is over, we're going to be posting audio from this webinar on our website, retailassociation.org. What I will do is send all of you a link and an email once that's posted, so if you have any questions or want to go back over this content again, you'll be able to do that. That should be up on our site sometime next week. I do want everybody to feel free to type in questions in the Q&A chat box you see in the lower right-hand corner of your screen. Scott is more than comfortable to handle those questions on the fly if that's appropriate, or to say that's going to be covered later in the presentation, so you just need to show a bit of patience until we get to that point where he can expand on it a little bit more. But please feel free to satisfy your curiosity. Don't save it up or forget about it, as the case may be. Also, we have a poll up. It looks like most of you have already taken it. We do want to know a little bit about where you're coming from, whether you're doing business in Seattle or not. The reason that's up there, just to make clear, this is a body of law that's currently on the books in Seattle, but what typically can happen is a city establishes legal precedent in a state, and then other cities hear about it, talk about it, perhaps attempt it as well. So if you're coming in and looking at this from Enumclaw, or you're looking at it from Spokane, or wherever the case may be, this is still a good primer for you, because it's not unheard of that these laws and ideas could be tried elsewhere as time goes on. So I do want you to be aware of that, and that's one reason we want to know where you're coming in from. We do want to know whether you know about it. It looks like a good percentage of you do not, which is actually heartening for us. It gives us a better chance that you will pick something up from this presentation that Scott's going to give you. And also, finally, we just want to thank you again for being on board. I hope you enjoy this presentation. Scott is our contract lobbyist and has a trained eye on all of these laws, and we'll walk you through the ins and outs of it here in the next 45 minutes or so, and we will leave time for questions as well at the end. So thanks very much again, and Scott, I will turn it over to you.
Great. Well, thanks, Jim. As Jim said, I've been following these laws on behalf of the Retail Association for just about 2 years in the city of Seattle. Just to give you a real quick rundown on who I am, I'm a practicing attorney. Worked in government affairs for a long time. I was with the Master Builders Association of King and Snohomish counties for about 15 years. I was their legal counsel and director of public policy. And when I stepped out and went solo about 3 years ago, one of the first groups that I ended up engaging was the Retail Association. And there are many different aspects of Seattle employment law that you should be concerned with if you do business in Seattle. And as Jim said, it's not uncommon that the city of Seattle will have an idea and it'll be picked up by somebody else. So this is what I consider to be pretty important information for employers, especially in the real estate or in the retail industry, but also broader than that. So as Jim said, there are 4 ordinances we're going to talk about. Minimum wage, wage theft, the Fair Chance Employment Act, and then paid sick and safe. And the most controversial probably of the bunch is the minimum wage, and perhaps it's the most convoluted of the bunch as well. So let's start with just a real broad view of what this ordinance is. For 500 or fewer employees, the minimum wage is currently $10.50 an hour. 501 or more employees, the minimum wage is currently $12.50 an hour. The number of employees are worldwide. So if you only have 10 employees in Seattle, but you have 450 employees someplace else, this puts you into the larger employer category. And I do have a notation about silver level healthcare plan or better. We'll get to that, and these are the details about minimum wage that. Well, let's go through the slides here, and I'll come back to the healthcare thing. The minimum wage law applies to anyone who works 2 hours in any 2-week period in Seattle. And we have exempted a few people, people who are in learning programs, so work experience type programs, apprenticeship programs, the disabled, messengers, that sort of thing. Also, it's discretionary on the basis of age. So if your workers are under 16, they have to be paid at least 85% of the minimum wage. And then under 18, there's a discretionary amount that is between 85 and 100. So one thing that I did want to talk about a bit more is the allowance for the medical benefits. And here's the way this works. If you are giving your employees medical benefits, those benefits have to be at Affordable Care Act Silver or better. So silver, gold, or platinum. And I trust that you know what those categories mean. If you don't, go to the Affordable Care Act and that'll be delineated for you. But if you do offer health care and your employee opts to take the health care, you are entitled to an offset. So that offset is for large employers, if you do give medical benefits, you should be paying $12.50 an hour, and you get an offset for the medical that you offer. In 2017, that amount goes up to $13.50 an hour. and in 2018 that goes up to $15 an hour. For small businesses, 2016 is $12 an hour, 2017 is $13 an hour, 2018 is $14 an hour, 2019 is $15 an hour. However, if you are offering medical benefits and the employee is taking the medical benefits, then in 16 this year you have to pay $10.50 an hour plus the medical. Next year it'll be $11 an hour plus the medical. 2018 it'll be $11.50 plus the medical. In 2019, $12 plus the medical. In 2020, $13.50 plus the medical. 2021, $15 plus the medical. So everybody gets to 15 by 2021, regardless of whether or not you offer medical. And if your employee doesn't want the medical coverage, you cannot offset the minimum wage. They're entitled to the minimum wage without regard to a minimum wage or without regard to healthcare benefits. So I have a question about what if I'm a small franchise with 10 employees? Well, franchises are captured in this ordinance. So if you are, say, a Subway franchise that has 8 or 10 or what have you, or you are a cosmetic franchise or a tire store franchise or something like that, the laws do apply to you as a large employer. And that was challenged in the courts, and unfortunately that challenge did not prevail. So it does apply to franchises, the rationale being that if you're a franchise, even though your location has just a few employees, worldwide you have many more, and you have the advantage of being tied to a larger organization, which some others aren't. So I think I went ahead 2. Let's see if I can. Let's do 1. Okay, so let's talk about wage theft. This one is relatively easy. You have to maintain these records, name and contact information. You have to maintain records of rate of pay, eligibility for overtime. You must provide an itemized statement of pay. You have to pay a minimum wage. You have to pay overtime. You have to pay work off the clock. You have to pay tips, and you have to classify employees appropriately. So this turns out to be sort of the catch-all that says you really need to comply with the regulations that are in place. This has been the source of more open investigations than any other part of these 4 ordinances we're going to talk about. I think the reason is because it's kind of a catch-all category, and an employer who is paying under the table, or an employee who's not paying appropriate minimum wage, or someone who's not paying appropriate overtime will be captured by this ordinance. So that is really fairly straightforward. It's the net into which everything gets caught, but there's really not a lot to say about it because it is a pretty straightforward approach. So next we're going to talk about sick and safe. Now this is probably the most complex of the 4, in part because the other ordinances use numbers of employees to put you in different categories. So the problem with the sick and safe ordinance is that they use FTEs. So this ordinance uses full-time equivalents, not bodies. So in the minimum wage, it's about bodies. So if you have 500 part-time workers, you don't have all working half-time. You don't have 250 FTEs. You have 500 workers. So here there's 3 tiers. One is 4 to 49 FTEs. So if you have less than 4 employees, you are not subject to the sick and safe ordinance. However, if you have 4 to 49, your employees accrue 1 hour for every 40 hours worked. Tier 2, you're 50 to 249, 1 hour per 40 hours worked, and they can accumulate up to 56 hours. Tier 1 only accumulates up to 40 hours. And then Tier 3, which is the bigger businesses, 1 hour per 30 hours is what is accrued. And then that can accumulate up to 72 hours. So that is sick and safe. And just to give you an idea of what is allowed for sick and safe, medical and psychological counseling, relocation and other safety planning, seeking a restraining order, participating in a legal proceeding, or care for someone in your family who is sick. Your opportunity to take time off when you are ill or have some family matter to attend to. So that's sick and safe leave. And again, I don't have a lot of time to go into the excruciating details of these ordinances. We'll go into a little bit of that, but to the extent that you have questions about it, let me know what your questions are, and I'm more than happy to try to take those on. This is the one that I think has gotten the least amount of attention, and it is an issue for certain types of employment for sure. What the idea of fair chance employment is if you are a convicted felon or you have items in your record that would tend to make employers less likely to hire you, you should be able to either explain those or not allow the employer to investigate those items until you're further down the interview process than just the initial interview. So what the Fair Chance Employment Act prohibits is ads excluding applicants with criminal records. So you can't go out and say, I want to hire somebody on the sales floor, but if you have a felony, you need not apply. Your job applications cannot ask about conviction or arrest records at the first screening. So what that means is that your initial screening can't talk about that. You can talk about that later. And you cannot deny a job based solely on an arrest or a conviction record. So the second category here is that employers must delay criminal background checks until after the initial screening. I talked a little bit about that. They have to provide an applicant an opportunity to explain. So the rationale here is that if I've got something in my record, it shouldn't preclude me from getting to the second step of the interview. And when that second step is undertaken and I have a robust conversation with a potential employer, I can explain it away, hopefully, or mitigate my circumstances. So that's the second part of that. The employer must hold the position open for 2 business days and have a legitimate business reason to deny employment. So what that means is if you are considering someone who has been, say, they have a felony for embezzlement or something like that on their records, and you are hiring in a cash room, that would be a pretty good business reason why not to hire them. Or if they are just not qualified, if you find someone who is genuinely more qualified without regard to the background of whoever it is that you're not hiring. So that's the overview of the Fair Chance Employment Act. There are some exceptions, and that the exceptions have to do with people who are performing law enforcement-like functions. If you've got situations where it's a daycare, it's a sensitive issue. I'll let you look up those exceptions, but by and large, if you're an employer, you have to come up with a different reason. So I have a question that says, what if the position's in the finance department? That's kind of what I covered with the cash room. If somebody has a felony for embezzlement, say, you're not necessarily required to hire them in the handling of money if they've demonstrated that they've committed a crime in that particular area. Your best bet is to find someone who is arguably more qualified overall than it is to defend this particular part of the law. And this is the one that gets the least attention, or has gotten the least attention from the Office of Labor Standards so far, because I think there are some really good arguments why you should be precluded from hiring certain people. And also, as long as you're denying employment based on factors that are outside that conviction or that arrest, you're in a safe harbor kind of situation. So that's that particular piece of law. And this is a slide that talks about criminal justification, unsupervised access, legitimate business reasons. So obviously, a cash room or someone who has been convicted for a crime like that would be a legitimate business reason. So here is, we're going to step away from the 4 specific ordinances, and we're going to talk a little bit about how all 4 of these ordinances are, how they're reported by employees, how the investigations go, and what the ramifications for violating them are. So again, eligibility for all these ordinances, they apply to people who work 2 hours within 2 weeks. So if you have someone who is working for you, even on a very part-time basis, they do need to be paid the minimum wage. They do need to be afforded sick and safe time. So each payday, you have to document all hours worked, the basis of the pay, tips, gross wages, and all deductions, which I'm sure most, if not all of you already do, but you have to provide that. A written notice at time of the hire. So when you hire someone, you have to give them the name of the employer, the physical address, the phone number, an email, the rate of pay, specifically what the overtime eligibility is, the tip policy, the pay basis, and the payday. So you will get paid $10 an hour every 2 weeks. Every payday is Friday or the 1st or the 15th or whatever it is. After a certain number of hours, you'll be eligible for overtime, which is double time, time and a half, what have you. All that needs to be provided at the time of hire, and like I say, you probably already do that. So I wouldn't worry too much about that. For all these ordinances, you have to retain as an employer. You have to retain for 3 years for each employer their date of birth, the beginning of the pay period, hours worked each week. And if you don't keep those records and an employee complains about you, there is a rebuttable presumption that you will be liable for that. So it behooves you to keep good records, and I would hope that all of you already do, but this is an additional reminder. You are precluded from retaliating. I have a question about whether or not records can be kept electronically. I believe so, as long as they can be produced. So what you're going to get is you're going to get an employee that complains, and as long as you can produce those records, you're going to get a discovery request, and as long as you can produce those records, I believe the discovery regime at OLS is parallel to the discovery regime in the Washington State court system, and you can keep those records electronically. So specifically, I don't quite I don't know exactly what the rule is, but I would be relatively certain that you can maintain those records electronically. So, on retaliation, the point of retaliation is that if you've got an employee who makes a complaint against you, you can't retaliate against them by reducing their hours, by firing them, by giving them some lesser amount of work or a less classification of work. You can't bring up their citizenship. So if you've hired someone who has questionable citizenship or undocumented or whatnot, if they complain against you, you cannot go to the immigration officials and say, well, they're illegals, and that's not good. Now this third one here is a little bit difficult for retailers, and this is one that we bucked up against and couldn't get it out of the ordinance. There is a presumption that a seasonal that isn't hired at the next opportunity is being retaliated against. So in the retail context, if you go through a holiday season and you hire someone and they apply for the next seasonal opportunity and you do not hire them, it is arguably retaliation, and they could go to the OLS and argue that you have been that they have been retaliated against, which is not necessarily good for us. So it just behooves you to keep really good records about your employees and specifically why you're not hiring them, because this is a presumption that can be defeated. And you can see the employer argument that will win the day is that the action would have been taken in the absence of the protected activity. So if you don't hire that person, regardless of whether or not it was retaliation, they were a bad worker or they weren't available or they did something that would justify your not hiring them. Investigations. So you've got an employee who has made a complaint. You are going to be asked to produce certain things in an investigation from the Office of Labor Standards. So this is their standard for investigation. They have to have a reason to believe that it has occurred or will occur, and the also the class of business and workers who are vulnerable. So the OLS has the right to investigate situations where, say, fast food employers, they've gotten several complaints about fast food employers who seem to be doing one particular thing. All things equal, the OLS can go into another fast food employer and do an investigation without having a complaint about what you're doing. When an investigation is reported or made, you have to post as an employer that an investigation is going on at your place of employment, and you have to allow possible violations for the last 3 years to come forward. So someone who maybe could have made an argument against you 2 years ago, who didn't say anything at the time, finds out that there's an investigation going on, they now have the right to make a claim against you. So that's something to be very wary of. And once you post the fact that there is an investigation going on, I would argue that you're gonna get some of these people coming out and making claims against you. So better to be on the right side of the law so that this doesn't happen. Penalties. There are many penalties that OLS is authorized to levy. Liquidated damages, which is basically a settlement where you can't determine exactly what the damages are, and you both agree that it's worth $1,000 and the case goes away or something along those lines. There are civil penalties, so these are fines essentially. Back pay. So in the case of the minimum wage or the wage theft, if you haven't paid overtime or you haven't paid proper wages, they do have the ability to go get that back pay. There are provisions for fines. There are provisions for interest on top of unpaid wages, and then finally taking corrective actions. So that would be something along the lines of a restraining order or an order by the director that you shall not engage in these uh, processes going forward. So here's the penalties. The good news is that the how are employees typically, let's see here, typically posting investigations? I don't know. Um, this is not something that I've seen in practice. So I am not sure, but we can talk to OLS and we can ask them specifically what the expected procedures are. So I'll do that and I'll get back to you. So violations. Your first violation for any one of these four ordinances is $500. However, it's discretionary. So what the OLS has said is, we know that these regulations are new, and if an employer finds itself in violation, the director has the ability to dismiss those first allegations. So we're kind of being given a bit of a free pass because these regulations are new. There are some questions that still have yet to be answered. So we'd rather get it right than penalize employers. The second time, however, these actions are mandatory, for $500 for the first violation, and then double wages are collectible as well. With retaliation, there is back pay will be levied plus a penalty up to $5,000. That's discretionary on the part of the director. So I wouldn't expect it to be $5,000 right off the bat, but if you're a bad actor, it'll get there. If you've got a willful violation where you are not paying overtime because you don't want to, and you're willfully not doing it even though you need to, or if you are in some manner not paying what it is that you're supposed to be paying, that's a $750 fine the first time. Second time, it's a $1,000 fine. And if you're willfully impeding an investigation, that's a $1,000 to a $5,000 fine. And again, that's discretionary. So if you're a bad actor, look for the $5,000, and if you're willfully impeding for the first time, it's probably going to be closer to $1,000. So here's the appeal process. Within 15 days after a decision has been made by the department, you can take it to a hearing examiner, and then after that, if you don't like the decision of the hearing examiner, you have 30 days to take it to the King County Superior Court. If you fail to comply with an investigation and an order, a subsequent order, you can be sent to collections. They can take civil action against you. They can suspend your city licenses. There is liability for successor businesses. So, shutting down your business and opening up as a new LLC or bringing on another partner, not so much. And then finally, they can bring suit at Seattle Municipal Court for any one of these actions. Private right of action. This is one of the more controversial issues, and that is that, as I wrote here, any person or class of person that suffers financial injury as a result of an employer's action can bring suit. So, or bring a complaint. So this is any person or class of persons. So if you are discriminating against a particular class of person, whether they be of a particular color, of a particular gender, of a particular sexual preference, of a particular belief system, or whatnot, you may find yourself with a private right of action where someone can complain against you. If you have 50 or more employees as of now, you are in the bucket for private right of action, so you can be complained against by someone with a private right of action now. And if you're a smaller employer, that will apply to you as of 2017. What else do we have? We have the employer size determination. This is quite interesting. This applies to everything but, as I said before, the paid sick and safe time, which is based on FTEs. So the way that we work, or the way that we determine the size of an employer, is the average number of employees per calendar week during the previous year. So what this is accounting for businesses that ramp up and ramp back down. So if you have 50 one week and 10 the next week, it all averages out. If you had no employees last year, then it's the employees in the first 90 days of the current calendar year. So that's how you determine how many employees you have. Where are we here? Integrated enterprise. This is potentially a big deal for retail employers, and here's why. Uh, Retail employers will, from time to time, retain by contract temporary employment agencies to provide 10 or 12 employees at the holidays or something like that. So it is arguable as to whether or not the size of the temporary agency is the one that's counted for these regulations, or whether it's the size of the employer that is calculated for the purposes of these regulations. So that's something to be very wary of. The other thing is that there's a sliding scale of degree of interrelation. So if you are, say, I can't think of a good example, but somebody who is a retailer who has a number of outlets, but then you have a smaller concept that has only 10 employees. Because you have an interrelation with the bigger employer that puts you in the large employer category, you probably will be determined as a large employer. Also, common management is a determining factor here. So if you have ABC company, XYZ company, and 123 company that are all under the same management, the OLS will aggregate the number of employees to determine what category you fit into. So just because you may be an LLC that's owned by a bigger company doesn't necessarily mean that you fit into the category of a smaller company. Central labor relations, that's another factor that they'll take into consideration, so that if you do a centralized hiring, centralized scheduling, things like that, you will likely end up in a bigger employer category as well. And then finally, common ownership. So if you are an individual that is a part owner of 4 or 5 different companies, and each one of those companies employs 20, you may be adjudicated to be employing 100 because you've got 5 different companies that you have a common ownership in. So there are many, many questions about these 4 ordinances that have not been fleshed out because they're relatively new and they've only been on the books for a short period of time. So I wanted to just give you an idea of how many of these investigations are going on and how many violations the Office of Labor Standards has found so far. This is from the Office of Labor Standards website. So in sick and safe time, year to date, there have been, which is about half over, paid sick and safe time, there have been 17 investigations and one violation. The Fair Chance Employment Act, there have been 5 investigations and 3 violations. For wage theft, there have been 17 investigations and 1 violation. Minimum wage violations, there have been 13 investigations and 1 violation. So not all that many completed investigations to report. But the good news is that when you look at these ratios, you're dealing with a fairly low number of investigations, but you're dealing with just a handful of violations, which means that the employment community is getting it right more often than not. In terms of open investigations right now, the OLS reports that there are 80 open investigations with regard to wage theft. There are 68 open investigations with regard to paid sick and safe time. There are 64 open investigations with regard to minimum wage violations, and there are 9 open investigations right now for the Fair Chance Employment Act. So, to give you an idea of what their workload looks like, it's about 200 or so cases that they're investigating right now. So that said, I believe I'm to the end of my formal presentation. There's some contact information if you want to get a hold of me to talk about any of this stuff in particular, or Mark. Karina Bull is also a great resource. She's the senior policy analyst over at the Office of Labor Standards and has handled a lot of this analysis and drafting and investigations and what's going on. So with that, I will be happy to entertain some questions, and we will see if we can answer whatever's on your mind. So I have a question here. If you're involved in an investigation, will you help me? Um, well, I don't know if I don't know exactly how the retail association is set up. I'd be happy to talk to anybody offline as to what our best practices might be, and it might be a good idea for the retail association to kind of put together a compendium of best practices, um, going forward in terms of what employers should do to avoid being